right, good afternoon, everyone. Courtney Brown from the Professional Development Committee, and this, I believe, is one of our last educational sessions of the 2019 AANA National Congress. And these boys packed the house. So nice to see everybody here. I'll let these gentlemen introduce themselves, and let's get started.
Good afternoon. I'm John Fetcho. I am the Director of AANA Insurance Services. For those of you who might not know, AANA Insurance Services is a wholly owned subsidiary of the AANA. We are part of the AANA. We are there to help our members with insurance-related matters. You don't have to buy insurance from us. We're there as a resource to all members. We're going to be putting on a mock deposition today for your education and potentially your entertainment value. This particular session is sponsored by Medical Protective. Medical Protective is the insurance company that we do business with, so we are very grateful for them for sponsoring this and putting this on for us. Today, there are going to be two gentlemen who are going to be helping us with this mock deposition. The first is Dr. Steve Mund. Dr. Mund is the President and CEO of SJM Consulting Services, LLC, in Mount Pleasant, South Carolina. And we actually have an attorney here who is actually going to be the villain, if you will, in our play here, so to speak. That's Charlie Redden. Mr. Redden is an attorney for Cunningham, Meyer, and Vadine here in Chicago. So with that, I'm going to throw the ball over to Charlie. You going to start us off here? Steve's going to start us off here. So we'll have a question and answer period at the end if you have any questions. But if there's something specific that doesn't make sense or you really need to know, feel free to raise a hand and step up to the mic as we're talking. We're probably going to be looking at two different cases. I don't think they're ones you were involved in, were they, Steve? No. But they are two actual cases. So these are the information you're going to be getting is going to be from actual cases. These aren't just made up to take care of the session here today. These are two actual cases. Steve?
Thanks, John. Before I turn it over to Charlie, just the usual disclosures. We have no financial relationships, and we're not going to discuss, obviously, any off-label use. The learner outcomes are listed there in your app, and so, Charlie.
Okay, good afternoon, everybody. Again, my name is Charlie Redden, and for the last 33 years, it has been my privilege to be defending and representing healthcare practitioners, physicians, nurses, nurse anesthetists, anyone affiliated with the healthcare field. I only do defense, so I'm not one of the bad guys. A show of hands, how many of you have never given a deposition? Never given a deposition? I should say yet. I can't say or suggest you're ever going to get sued, but if you practice in the field of healthcare for any length of time, chances are very good that someday you are going to get a subpoena or your boss or your employer is going to get a letter asking that you give a deposition. For some of you, this is going to be a frightening thing to learn, and to some extent, it should concern you. I'll explain why. But there are ways that you can prepare, and I want to address some of those things today before we do the mock deposition. The best and most significant way you can prepare yourself when you are asked to give a deposition is to, if you're insured directly, contact your insurance company, tell them, and ask for an attorney. If you're employed in a group, go to your boss, tell them you've been asked or been subpoenaed to give a deposition, and ask for an attorney. Now that may seem like self-serving advice. It is not. Although I do that work all the time, I have presented healthcare providers, my best guess would be at least 500 times. I have taken depositions at least 1,000 times and been present for probably 2,000 more depositions. I've done this many times, and I have seen the consequence of healthcare practitioners giving a deposition without preparation and without representation. Now, what can a lawyer do for you? You're the healthcare provider. You know the medicine. What can we do? There's a lot that we can do before you get sworn in to give that deposition. We can get medical records that you don't have access to. We can get deposition transcripts, read them, and advise you of what other people have said before you give your deposition. We can and do communicate with other attorneys who are involved in the case and find out what are the issues and what might be the questions that we pose to you. And we can give you the experience that we have in preparing you on how to give a deposition. And even if someone you know has given one and says, I can lead you through it, your boss says that or a fellow practitioner says that, the fact of the matter is that you should have someone there to represent you and prepare you and be with you during that deposition every step of the way. If you take nothing away from today's discussion, know that you should always get an attorney to help you through this process. All right. Give me that clicker. There you go. All right. I'm going to quickly go through some of what you need to know to get prepared for a deposition. If I were to be representing any one of you for this, the process would take a long time. We would probably meet initially, go over the records, the issues of the case, whatever the matter might be. We would do this on a day separate from when you're giving a deposition, and we would do it again on the day you give a deposition. The process cannot be, it can be summarized here, but it can't be mimicked here in such a short period of time. Get my notes here. What do you need to know to be prepared for a deposition? You need to know the medical records, the scope of your involvement. It would be helpful if you knew what happened after your involvement ended and your lawyer can get that information to you, so you have some concept of why you may be asked to give a deposition. You may be asked because you're being sued. You may be asked because one of your fellow healthcare providers is being sued and they want information from you. You may be asked to give a deposition because in the world out there, because of patient privileges, lawyers can't ask you questions about what you did or why you did it other than in a deposition. So it may not be something that's terribly significant to you in the end. It may be very significant, and you don't know that going in. So the lawyer, and with your help, will help you get the information you need to help you get the concept. Am I being asked to give a deposition because I'm at risk? Am I being asked to give a deposition because a fellow practitioner is being sued or is at risk? Or are they just trying to get some basic information from me because they need interpretation of my records or so forth? In preparation, then, the most important thing typically is to know the records. Know what you have done, know when you did it, know why you did it. During a deposition, those records will be with you. They'll be in front of you for you to look at when you need to, but you should have studied them and you should know them before you go in that deposition, so as the questions come to you, you can process, why are they asking this? What do they know about what happened during the procedure that they may be asking this particular question? In advance of the deposition, in addition to meeting with your lawyer, going through the records, learning what the nature of the case is and why you're being asked, you will ultimately be asked to consider hospital or policy or internal guidelines and policies, and perhaps industry or national standards. So in advance of your deposition, you should consider, is anything that you did or any conduct that might be asked about something that is discussed and established in a hospital guideline or policy, a internal policy that your group may have, or some national standard? You do not want to be surprised at the time of the deposition when the other attorney pulls out some guideline from your society and says, well, doesn't it say you should have done this, this, or that? These are the kinds of things that you and your attorney will work together on. The deposition, my notes here. Right. After you've prepared with your attorney, you've reviewed the records, you've considered guidelines, and you understand the nature of this proceeding, why you're being asked questions. The day of the deposition, it's important to you that you have it set up in a way that's convenient and appropriate. For example, You do not want to be coming off a shift, going down to some administrative office, and then giving a deposition. You do not want to be doing this at the end of the day when you're tired. You want to give your deposition when you are ready to do so. Typically, you want it to be the first thing you do that day after you again meet with your lawyer. You want to have it done in a place where you feel comfortable, and most of the time you have some say and control over where the deposition will proceed. Make sure that you voice that to your lawyer, and make sure that the time, the date, and the location of the deposition suit you. You want to be as comfortable as possible. You, of course, want to have the records with you. As part of your preparation, and this can't be emphasized too much, you need to, before you go into that room and get sworn in, you got to remind yourself that you control the deposition. And you may think that you're the one that's going to be, you're being asked the questions and you have no control. It's the opposite. You have complete control over that deposition. You have control over what questions you answer. You have control over how you answer them. You have control over the pace of the deposition. You can make it slow down. You can, at appropriate times, you can ask for breaks to consult with your attorney. But most importantly, I think, and I tell this to every client I present for a deposition, before you go in there, remind yourself you're really good at what you do, and you did what you should have done, and you need to be confident. It's difficult to go into a deposition, as fearful as you might be about the proceeding, but if you go in there with confidence, then your testimony will show, and it'll be appropriate, following the guidelines I give you. You will give confident, short answers to the questions. You cannot win a case if you're being deposed. You can't win that case during your deposition, but you can lose it. And I've seen it happen, where witnesses attempt to defend themselves, defend the case, try to win the case with their testimony during the deposition as opposed to just answering the question. If you go in with confidence, you'll do well. Okay. Right. In every deposition preparation session I have with a client, whether I'm presenting a defendant, whether I'm just presenting a practitioner as a witness, even if I'm presenting an expert witness, there are 3 rules, and I tell everyone the same thing. If you follow these 3 rules, you will do well. If you vary or deviate from these 3 rules, you are in trouble. And there's only so much that I can do during a deposition if you vary from these 3 rules. They are quite simply this. Get a clear question. Now that seems as common sense as anything. But you would be surprised at questions that are asked of witnesses. And the response that the witness gives is, well, by that do you mean this? Well, if you're talking about this, then maybe the answer would be that. But if you're talking about this, then the answer would be this. And what you get is this back and forth where the answer is not an answer, but a question back or a clarification back. And what you're saying with your words is, I didn't understand that question as you phrased it. And what you should say is, could you rephrase the question? You control the deposition. You do not answer a question that you, as in the words that were used, do not answer the question that you do not understand word for word. Before you start to give an answer, think to yourself, do I understand exactly what's being asked of me in the context of this case, in the context of my involvement? And if you don't understand that, then you don't understand the question. It's hard because you don't want to sound or come across as being stupid, but if you insist upon a good, clean, clear question, it's half the battle. Step 2. Nope, we missed one. Well, we skipped they skipped 2 in the slides, my apologies. If you get a clear question and you're listening, you're doing your job, you're listening to the question, you're not starting to answer it or formulate an answer until the whole question's been given to you, you pause, you stop, you ask yourself, do I know the answer? Do I know the answer to this question? If they ask you, do you recall, a memory question, most times your answer is going to be, I don't recall, because this took place 2-3 years ago. I've had 500 cases since then. I don't recall. Do you know? You know things 3 ways. You know them because you do recall. You know them because you wrote them down in the chart, or you know them because that's what you always do in that circumstance. If you don't recall, or if the question is, do you know, and you don't know the answer, what's the answer? Now, I got to tell you how many times in a deposition a witness will say that, and they stop and they start to say, you know, I'm sounding dumb. I'm saying I don't know too much, and they start to give information because they don't want to come across as not knowing things. But if you don't know the answer, that's the answer. I don't know. It's not in my chart. I don't remember it, and I can't say that I do it every single time. Now, I tell the client before the deposition one more thing about those kinds of answers, I don't recall or I don't know, because you're hesitant. You want to give information because you think, I should know the answer to this. Your attorney, in almost every jurisdiction I've ever been in, gets to ask you questions at the end of the deposition if they haven't been asked by the other side or the other attorneys. So if you gave it, I don't know, or I don't recall, but there's some information that needs to be expressed during the deposition, your lawyer can still bring it out later. So be confident. If you get a clear question, and if you don't know or don't recall, then just say so. Then there is the golden rule. Just answer the question. You will see some examples of violations of this rule. It happens all the time. And as I tell my client, you're going to do it during the deposition. I'm not going to kick you under the table when you do it the first time. I'm not going to say anything when you do it the second time. But if you hear me say to you during the deposition, I think you've answered the question, that is my very polite way of saying, shut up. All right? Why is that important? Quite simply, if you're saying more than the question asks for, you're giving away information that's going to invite 5 or 6 more questions that they never thought of. And you're also getting defensive, and you're also trying to win the case by giving more information that's being asked for, and you're digging a deeper hole. If you just answer the question and wait for the next one, you'll do just fine. If you follow those 3 rules, you'll do well. Now, it's not enough time, and we want to do the practice session quickly. There are a number of things that happen during a deposition, and your attorney, when they prepare you, will alert you to them. Things that are very common in depositions that until they happen to you or until your lawyer explains them to you, you might be very surprised. You might get a question like, what is the standard of care? I don't know, isn't that a lawyer question? I don't know. Well, you should know when you get that question what the question is asking you for. Your lawyer will prepare you to say, standard of care is what a reasonable practitioner of similar training and experience might do under similar circumstances. It's sort of a universal standard. They will use that phrase, what's reasonable under the circumstances, in other questions. And so when you hear a question put to you, did you do that? I did. And you would agree that that would be reasonable to do under those circumstances. What they're saying is that's standard of care. You got to always be mindful during a deposition when you hear those kinds of words, because you're not only binding yourself to that being what should have been done, but you're also probably binding someone else who may not have done that same thing. Always be mindful of your testimony might be used not to get you, but maybe to get a fellow practitioner. So that's why it's important to have a lawyer tell you what the case is about and who else is involved. You might get a question posed back to you, well, that would be speculation, wouldn't it? And you have to stop and wait, because if you admit that something is speculation, you're basically saying, I can't say this in the courtroom. Now, because you don't know for certain the answer doesn't necessarily mean that your answer is speculation. You know, does this blood pressure mean that the patient has lost a great deal of blood or something? A terrible question. You want to be careful in how you answer that question. If they say, well, basically that would be speculation, then if they throw that back at you, be careful and mindful that, well, it's reasonable to conclude that that blood pressure is not evidence of a loss of blood or whatever the circumstance might be. Don't admit to something being speculation, because that means you can't say it in the courtroom. Another trick that's very common, and there are lectures and presentations on this very issue. Questions being posed to healthcare practitioner where they confuse what's called the standard of care, what's reasonable under the circumstances, and they talk about what's safe, what's dangerous, whether or not that a standard of care is equivalent to rules of safety, safe practices. The reason that this is done, and I don't want to dwell on it too long, the reason that this is done is because when people hear those terms of danger, safety, rules of safety, they tend to react differently. And if you start to equate what's standard of care with what's safe, you're playing into the hands of the plaintiff's attorneys. And frankly, what you do as nurse anesthetists is not very safe. You're bringing people to the brink of death, keeping them there, and then reviving them. Was that safe? It was necessary, but it wasn't necessarily the safest thing to do. And if you start equating safety to standard of care, then you're putting yourself at risk. Again, these are the tricks of the trade. These are things that we have learned over the countless depositions we've presented doctors and nurse anesthetists and nurses and other healthcare providers, or taken their depositions. We know the tricks. And again, if you are asked or when you are asked to give a deposition, I can't emphasize enough, get yourself an attorney, someone who's there to prepare you and represent you at the deposition. So Dr. Mund and I are now going to go through, these are actual transcripts of actual depositions of nurse anesthetists. I have, and these are two cases of mine, I've changed all the names. So if you hear a name, a doctor, a hospital, or the witness, these are fictitious names, I promise you. But everything else about them is real. One case had to do with a claim of lidocaine toxicity that they claim occurred during the course of an operation. The other was where the CRNA in a community hospital in a rural area was called upon to take a patient went to surgery. It was started off as a MAC anesthesia. They had to convert it quickly to general anesthesia. Things went south. Everything was done in the absence of the attending anesthesiologist who was at home and was unable to get to the hospital before the surgery. So these are depositions given by certified nurse anesthetists. And I've picked out examples of where one or more of those three rules were violated. So what we're going to do, Dr. Mund and I, is we're going to do some of those question and answers. We're going to read them, as if at deposition. And then we're going to stop and we're going to ask, can you identify where they broke one of Charlie's rules? Okay? All right. And as a reminder, I'm asking the questions as a plaintiff's attorney, and these are being answered by a nurse anesthetist. If I look at your anesthesia record, is that the packed red blood cells that are listed as being done at 201? I read that wrong. Being listed at 148?
I would assume so. Like I said, the unfortunate part of my record in particular is I did not get a chance to chart everything I wanted to.
All right. You said you only gave her 1 unit of packed red blood cells during the procedure, correct?
Yes, sir.
The only packed red blood cells that is listed here is a unit hanging at 148, correct?
That sheet I'm looking at, yes, sir. We are looking at 51?
Yeah.
CHC 51, sir?
Then it says here, fresh, frozen plasma was started at 201.
I have, yes, sir.
I thought you said that you did not hang any other blood or blood products before the code.
What time is the code, sir?
I think the code is listed at 2:43 per the code sheet.
I see the time you're referring to here, sir.
So did you give fresh frozen plasma in the OR before the code?
I must have. I did not, truthfully, I don't remember giving that.
So if this record is correct, the record on page 51, you would have given her 1 unit of packed red blood cells that was already hanging and 1 unit of fresh frozen plasma before the code, correct?
It looks that way.
Okay. Did you ever order any labs before you took her to the OR?
No, sir.
How about any intraoperative labs?
Not intraoperatively, no.
Did you draw any intraoperatively?
Once the code was called, yes.
What did you draw?
I asked for clotting cascade, I asked for a DIC panel, and a CBC and lights.
Were they ever done?
I believe so.
Do you see the results of that in the chart?
No, ma'am. I will double check that. I did not see them earlier.
All right. Leave it there. So, anybody want to tell me or tell us where they saw some issues or problems with the testimony there? Everything. Okay.
He didn't take control of he didn't take control of the deposition.
Right.
He's much more defensive.
So clearly wasn't personally prepared, and I'll be honest, in this particular case, the attorney could have done a little better job preparing the witness. Wasn't me. But didn't know the records, didn't know what was done or what wasn't done, at least by what was charted, and then speculated a bit. You know, I must have, I think I did, so forth. Again, classic rule, if you don't know, you don't know. If it's not in the record, then you don't speculate. Go on to the next one. Do you recall if Dr. Carter was looking at the monitors during the time period from 1540 to approximately 1600 hours?
No, I don't see them.
When do you recall Ms. Brady's vitals to start dropping? What time?
Without looking at the record?
Well, tell me first of all your independent recollection, and then we'll talk about times. Tell me about your independent recollection, and we'll look at the times in relation.
It was very close to 4 p.m.
Can you give me an approximation? 5 minutes, 2 minutes, 10 minutes?
I don't recall exact.
Would it be less than 10 minutes?
Yes.
What do you recall observing?
Just that her heart rate was starting to come down.
Did you notice anything regarding her blood pressure?
I mean, I don't recall, but it was starting to come down also.
How about her O2 saturations? Do you recall those coming down as well?
No.
Besides her heart rate dropping and her blood pressure dropping, were there any other signs that she was in distress?
No.
Did it happen, was the sequence first the heart rate dropping, then the blood pressure, or the blood pressure, then the heart rate, or was it relatively simultaneous?
I don't recall.
Let me do the next one. Did General Hospital on September 5, 2011 have a massive transfusion protocol?
Off the top of my head at that time, I'm not sure.
Do they have one today?
Yes, sir.
Do you know when the massive transfusion protocol was first initiated at General Hospital?
I do not.
I take it a massive transfusion protocol was never initiated for Samantha, correct?
I don't believe so. I'm not exactly 100% sure. I asked for, throughout the events, of course, virtually everything on the new protocol or protocol that I had seen at this point. However, I don't believe that the term massive transfusion protocol was actually called.
Could Dr. Bombay have ordered a massive transfusion protocol?
I think that'd be very difficult for him in the sense he was not there to see the patient physically at the time.
If he had been physically present in the hospital and taking care of Samantha, could he have ordered a massive transfusion protocol?
I don't know the protocol 100% off the top of my head, sir. I would say it'd be more towards the person that is actually treating the patient versus an anesthesiologist that is only getting 15 minutes of that patient's care.
Can a CRNA initiate the massive transfusion protocol?
I'm not sure.
When the massive transfusion protocol is initiated, is there a special mechanism that gets set in place with the blood bank that you know?
I was under the impression what happens if someone orders the massive transfusion protocol. Let's say we are in the operating room. The operating room nurse actually calls down to the lab and tells them that we're doing a massive transfusion protocol, and they tell us the next steps, that they need, in particular, blood draws. They come back and let us know how much blood is available and when these things are available.
So the lab has input with the massive transfusion protocol?
I believe so, sir.
Anybody see the problems in there? Someone just shouted out. Say again? A little bit there. Talking about responsibilities or knowledge of other people, it's really not your job to talk about that. Didn't know the protocol, didn't know if it existed, and told the attorney what it probably said.
He implied that the anesthesiologist could do it, but he wasn't there. But he was the person who should be able to do that would be the best, which was him. But he also said that he wasn't sure that he was capable of doing that. Right. So he just put himself as being like, I can't do it, but I was here, but I should be the one who's doing it.
Yeah. A lot of speculation in there. A lot of this can be avoided by simply asking yourself, do I know the answer? And if I don't know the answer, don't go beyond that. He didn't know if there was a massive transfusion protocol at the time of this incident. Why would you talk about what it probably said and who was involved in it if you don't even know it existed? It was a pretty simple matter to deal with if you just follow the rule. If you don't know, say you don't know.
Didn't he do any free trial education on himself?
I don't know. I was a observer of that auto accident as it unfolded in front of me. It was a bad day for the provider, and a lot of it, as you indicated in an earlier question and answer. There was no documentation, and after the surgery had been completed, he made a decision not to complete his documentation for fear that it would look bad. So he left the record blank in many respects and was relying on his memory at deposition a couple years later. So that's not a deposition prep, that's just the fact that by the time he got to deposition then he was rattled, clearly. All right. Okay. I have just a general question now. Can you tell me what the physiological effects are on the body of prolonged hypotension?
Yes, sir, I can.
Go ahead.
What would happen is for a person that is long-term, it depends on every patient, depends on each situation. They're all different, but physiologically, thinking the longer that a person has hypotension, there's a stronger incidence of having cardio, renal issues, neurological issues.
What cardio issues?
They could, like I said, each person is different. A person normally runs with really high blood pressure. You give them hypotension, and they're at higher incidence of having strokes or an MI. In particular, those cardiac patients can also go in renal failure a lot quicker. Neurologically, patients can have strokes. Some people actually call that perfusion brain. I don't know if you have heard that term, or pump brain, like patients are coming off cardiac bypass surgery.
Any other physiological effects of prolonged hypotension on the human body?
Yes, sir.
What are they?
Hematologically, you can have some issues eventually because what happens, your core temperature ends up dropping. That can affect your clotting cascade.
Anything else?
Overall, perfusion to the body tissue can cause some acidosis.
What is the effect of prolonged hypotension on the liver?
Liver is basically an organ. Let me back up. Easiest way to answer that question would be filtration process. Not enough blood to help filtrate. Liver also is in charge of part of the clotting cascade as well.
We'll probably stop there. I would have recommended that first question. Just a general question, what are the physiological effects on the body of prolonged hypotension? That is a question that you should never, ever answer. You are in this particular person was in a deposition, this person was being sued as well as others. This has context, this issue. The question doesn't. And to answer a question outside of any context like that is problematic. You're just giving all these consequences of prolonged hypotension, which this patient had. But you're just saying generally, I know all these things, these are what's going to happen. You're laying out the plaintiff's case for them in answer to a question you should never have answered in the first place.
What would your answer be to that?
So you get a very broad question like that. I mean, hypotension has a definition. What are the physiologic effects? It depends. Well, then they ask the follow-up question. Well, it depends on what? Well, it depends on the circumstances of the patient. Well, what about this patient? Well, what about this patient? Well, when this patient first had evidence of hypotension, okay, at this time. What was happening at that point in time? I don't know. Might it have been, could it have been these things over time, possibly? You just deflect and answer simply the question posed, but don't go and give them, you know, some sort of recitation to show how smart you are about the physiological effects of hypotension, because all this is going to come back at you at trial. Please.
So at the beginning of that, when you're asking, I mean, could you restate the initial question again?
Could I, or?
Yes.
Yeah. The first question was, I have a general question. Can you tell me what the physiological effects are on the body of prolonged hypotension?
So you would then answer, it depends, because if you say yes, then if you say, well, then go ahead. I mean, we're supposed to have a general idea of what is this, so you just say, it depends.
Yeah. It's vague questions, and again, this is part of the preparation that you would have with your attorney. Vague questions or broad questions like that, you have to be very careful. If they're...
Could you go back and ask them, can you clarify your question?
Sure. Again, that goes to the fundamental of who's in control of the deposition. They get to ask any question they want, but you don't have to answer it. And you can continue to kick it back to them until piece by piece you're comfortable with not only the question and the answer, but you're not giving it up. You're not saying, because you know in this case this patient had a period of profound hypotension during surgery and they want you to announce what's going on and what the possible consequences. They may get there eventually, but you don't give it to them like this. Sir?
So, in a case like this, where you perceive that there's certainly traffic, can you pause the deposition to consult with your lawyer?
It's a very good question. In most jurisdictions, the answer is no.
Repeat the question.
Can you pause? Basically, if you're faced with a question of some difficulty, can you stop and say, I want to talk to my lawyer? And the short answer is generally no. So what we talk about in advance of the deposition is you have to be mindful of what's coming down the road. So you get that first question. What are the physiological effects on the body of prolonged hypotension? Well, that would depend upon the circumstances. I need to take a break. You've answered the question. You've answered the question, and you have every right to take a break. And they don't get to ask you what you talked about because you're talking to your attorney is privileged. So I always tell the witness, if you see something, get rid of that question however you can, and then ask to take a break. Go out, we talk, we consult. They're asking me about the consequences of hypotension. This happened during the, of course you should have prepared for this. But that's how you deal with it. And again, you control the deposition. You can get rid of almost any question with a simple, it all depends, who knows, it's too broad a question. And then you say, I'd like to take a break.
How many breaks can you take?
There's no limit. For questions in the back, if you could go to the microphone or speak loudly, because I can't hear you. Right. Right. So they are entitled to ask you if you have what's called independent recollection. You remember certain things without looking at anything. And you should be prepared for that question. You should also be prepared to say that the specifics of the care provided, the time and so forth, I don't have an independent memory of, and I would need to look at my charting. And say that up front when asked, do you have an independent recollection? And therefore, when the questions are, well, when did the patient first start to show hypotension, whatever that was in the prior portion we read, when were the first drop in heart rate? The witness was actually answering from memory at that point, and he should never have done that. He should have had the chart in front of him, and all you do to get that is to say, I don't have an independent memory of times, of events, I need the chart, and then you're entitled to it.
I wanted to ask about that moment also because he asked about when did you see a drop in blood pressure? Well, you can induce the patient, they can have a drop in blood pressure, but it not be a drop in blood pressure that is going to cause any issues.
Right.
It's just the fact that they're asleep. But then he followed from a decrease in blood pressure, decrease in heart rate, and then he turned it into it being a consequence of hypotension. So I thought that the two links, you can say, yes, they had a decrease at this point, but that doesn't mean that they were at a point of trouble or that they were in trouble. So how do you stop that? Because, yes, I noticed a decrease in heart rate and blood pressure here, but then he said when you were starting to have problems, he turned it into it being something that was going to be a negative versus it being something that was actually noticed in the chart. It may have been a decrease, but not actually when the patient had the significant decrease in blood pressure. So how do you prevent them from linking those two things, something that was normal to something that was happening?
Your instinct is common in a deposition, that is not to just answer the question, but to defend the inference that's created by it. By putting two things next to each other, the inference is they're either related or they're causing a problem. Your instinct is, I want to fix that right now. And that's an instinct you have to push down. Don't do that. If they try to make the connection in a subsequent question, you defeat it. If they don't make the connection, but they just have those two issues talked about, either you, on your attorney's questioning, will clear it up at the end, or you'll leave it go because your attorney says we're not going to go down that path. But you will want to do that in multiple circumstances in a deposition. They're asking a series of questions, and you think to yourself, well, I know what they're doing here. And you're starting to get ahead of yourself, and you're starting to play lawyer, and you're starting to figure out a way to defend yourself. And that's when you lose focus, and that's when you're not doing the job of just answer the question and then go on to the next one. Take them one at a time. If you see where they're headed with a series of questions like that, and you want to know, am I in trouble? Do I need to answer this better or differently? That's when you get rid of the question, ask for a break, and talk to your attorney. And there are no limits. Question. How much intraoperative blood loss was there from the time the procedure, from the time she got into the operating room until the time of the code?
I want to say probably, for me, I always count what I see physically, too. So I want to say probably together from the time I saw her in the ER until the time we were in the OR, maybe 700 total.
Do you know in 2011 if there was a written policy, a procedure at General covering the scope of practice of a CRNA?
Yes, there was.
Was there a written policy and procedure covering the scope of practice of an anesthesiologist?
I believe so. I have not physically seen that. However, I would assume there is.
Was there a written policy and procedure at General in 2011 regarding coverage of the CRNA by the anesthesiologist? For example, what types of cases needed to be covered?
Off the top of my head, I don't know, sir.
Do you know of any written documents at General that talk about when an anesthesiologist in 2011 was required to cover the CRNA?
I don't remember specifically, but I do remember faintly reading of that as well. I don't remember what it said in particular.
Okay. Those are two examples of how much intraoperative blood loss was there from the time the procedure began. And he totally guessed at 700, putting some factors together. Totally guessed. Don't guess. Second time about policies and procedures governing scope of practice and coverage and so forth, specific to him and specific to the anesthesiologist. He didn't know, but he still tried to give some information. If you don't know the answer, I don't know. All right.
Someone had a question earlier that stepped up to the mic.
Please.
You guys are on a roll. I didn't want to interrupt. Tom from Maine. I work in the VA. I was deposed 1 week ago today. So timing in life's everything. It would have been nice if you guys could have bumped us up. Goes without saying, everything you're saying is absolutely correct. I cannot be sued because I work for the government, so this lawsuit was against the United States government. I had a Department of Justice attorney who made it very clear that she was not my attorney. She was the United States attorney. But having said that, she was very helpful, supportive. I felt very well prepped. We had a 2-hour prep session for the 2-hour deposition. And basically everything you're saying she covered. And I'm here to tell you, if you have not been deposed, it's an unbelievable stressor. And you do want to defend yourself. You do want to defend your colleagues. My students tell me I speak a lot. So for me, controlling the volume of answers. And one piece of advice she had, which was critical, don't answer right away. Every single time there was a question posed, think about it. She said, because I need a chance to object. And if you answer too quickly, I've lost my opportunity. So, and she wasn't kicking me, but she was right next to me. She objected in 2 hours probably 15 times. Form already asked and answered. That was a quick one. Form, and then she'd look right at me and say, you can answer. And we had one break.
Right. So one of the tricks, and lawyers aren't supposed to coach the witnesses during a deposition. You know, this is the other side's opportunity to ask questions and your obligation under oath to give answers. And we're not supposed to say anything during the course of a deposition while we're on the record to try to suggest what the right answer should be. The one thing that I found very helpful, and my clients have found helpful, is what I tell them before the deposition begins, is a question is being asked. If there's something about it that I find to be potentially problematic in any fashion, I will put my hand in front of you. You'll see it. And that means don't say anything. That usually works. They see the hand, they go, don't say anything. I want to do or say something. Often what I will do is I will ask to have the question read back. I'm not suggesting anything by that. At least no one thinks I am. But what I tell the witness that I'm presenting before they go in, if I do that, if I ask to have the question read back, pay attention. Depositions get very conversational. The pace can get a little fast if you're not controlling it properly. Question, answer, and then all of a sudden a question comes and you don't see where they're headed. You don't see the difference. My job is to sit and listen and pick up those little subtleties. And I put my hand in front and I'll say, could you read that question back? And I've told my client, when I do that, pay attention. This may be one of those circumstances where they're sliding in standard of care. What would a reasonable practitioner do under the circumstances? This might be slightly different. They go from what's the facts of this case to general medicine. All of a sudden, they're back in the facts of this case. It's my way of saying, focus, pay attention. This question, it may not be what you thought it was. Listen to it. And the point was just made, and it is a great point. We all do this in conversation. We start to formulate our response before the question is done. We can't wait till it's our turn to talk. During a deposition, you've got to wait and let that person finish the question, because the end of the question may determine the meaning of it, not the beginning of it. So when they start talking about hypotension, and you're like, okay, I know where they're going with this, and you're starting to formulate your answer, and they haven't finished the question, you missed the question. And you give an answer that's not connected or properly connected to what was actually asked of you. So it takes some practice, and there should be practice before the deposition to pause and wait and listen. Right.
I was practiced pretty well, given a lot of information. When it gave a deposition, never heard anything about it since. Turned out later, I found out it was actually the nurse because she waited too long to call us home.
Yeah.
So where does it go from there? I mean,
Yeah, one of the things that lawyers are notoriously bad about is following up with people. We have experts that are holding on to files. They call you up and go, whatever happened to that case? Oh, that got dismissed 3 years ago. We depose people. We don't have the right to contact them other than in the deposition, so we can't communicate with you. But if you had an attorney or someone that represented you, prepared you, they should have just let you know what it's over with, or you're not going to be needed at trial and so forth. That's your contact person.
so it does go to a trial afterwards?
It might. It might. It might.
Or it may just end with...
Yep. I say 90% of all lawsuits filed are resolved short of a trial. So chances are after a deposition, that's the last you'll ever see of it. But if you want to know, you should ask the person who prepared you to let you know.
Charlie, I'm just going to throw a question up for you for these people. What happens during the deposition? I make a mistake in my answer, and I realize that, and we're in the deposition. And what happens afterwards? Because typically, in my experience, at least in my criminal world, when we gave any kind of testimony or deposition, we got a transcript of it to review before we signed off on it.
Right.
And what happens during that review process? I realize I'm a mistake. So maybe you can just do that, and we'll take some other questions.
So in Illinois, the rule is if it was recorded accurately by the court reporter, it is your testimony, whether it's in retrospect an error or not. You can't change your answer. However, you can, through your lawyer or other discovery methods, clarify or correct a mistake that was made. You can supplement the record. It doesn't get rid of the question and answer. That's going to stay there forever, unless it was you said yes and the court reporter typed no. By the way, they tape it too, so they probably got it right. But you can correct mistakes. If you know about it during the course of the deposition, then again, you can have your attorney ask you the question at the end. Remember earlier you were talking about what's considered to be a normal heart rate, and I think you said anything over 80 is considered to be fast. Did you wish to correct that? And they can give a different answer at that point. Both answers are still on the record. Both can be used at trial, however either side wishes to, but you can make corrections in that fashion.
Other question out there?
How many people and who are the parties in the deposition?
So that's a great question. Often when I present people, I ask the attorneys to identify themselves and indicate who they represent. I let the client know before we get in there, look, there's going to be the plaintiff's attorney, there's 3 defendants, you and me, and a court reporter. So you should have a sense when you walk in, if you're prepared, who these people are. But it's nice to know when someone starts to ask you a question, you'd like to know who they are. And I always just say, could you just tell my client again who you are and who you represent? Gives you maybe a sense of, oh, they're one of the good guys, or they're, maybe coming after me and my partners, whatever.
In these days of the electronic medical record, where we typically have vital signs that are recorded every 3 to 5 minutes, now you can break it down to every 1 minute.
Yep.
So, what you might present and print out is your record wasn't just vitals listed every 3 minutes. Now they expand it and have vitals every 1 minute.
So I'm not sure what the question is, though.
The question is, what will they, they have the ability to get vital signs almost second to second. What is printed out? What will be presented at court?
Yeah, so the bane of my existence in the last 10 years has been the advent of electronic medical records. You would think it's a great idea, it's a great thing. You can have, as you well know, the records continue to repopulate with all the data that preceded, and then you have a little note like this. The next note repopulates everything in that note. And the record is not necessarily, that it gets printed, is not necessarily what is known, because there may be continuous monitoring, continuous recording, at least electronically, but not necessarily in print fashion. And we end up sometimes, in many cases now, in great disputes over what is the medical record. I go back, despite how young I look, I go back to the days of handwritten records, and still, actually in your field, still the most handwritten information that you would otherwise see. Everything else these days is typed in. You guys still, in many respects, have the old little arrows and the V's and so forth. And then there's a dispute now because of electronic medical records. What is the record? Is it the data that stayed inside some computer that's printed or not printed, so forth? I had some questions over here when I would, or people.
I think I have a multi-part question, but part of it is correct any misconceptions I may have going forward in my statements. Sometimes it's cheaper to settle an issue than it is to go through the process of taking it to trial, something of that nature. Is that
Cheaper for who?
Those that have the ability to say, yes, we would like to enter into a conversation.
So
the reason why I ask this is I've been in many employed situations where the healthcare system is the provider of my malpractice insurance in terms of paying for it and all that.
Yeah.
And there are the possibility, even if a deposition goes very well, that provider of the insurance, the malpractice insurance, is representing both the hospital system as well as the individual provider. And I'm just curious as to what the implications might be if the defense person has sort of that dually responsible for both the provider and the system, and it's decided that the best course of action is to go ahead and enter into a settlement process.
So let me put this more in the context of what we're talking about today, but it's the same issue. And we actually talked about this morning before we came up here. If you have your own policy of insurance, you've paid for it, whether it's supplemental to what your bosses have or the hospital has or not, that will typically get you the right to have your own attorney. They will appoint an attorney just for you. If you're part of a group practice, which includes anesthesiologists and CRNAs, or if you're part of an institution that employs you, and the institution's a defendant and you're a witness, you may not be offered your own attorney. You may be offered the hospital's attorney. You may be offered the group's attorney to represent you as well as the group. And there are, as you can imagine, a myriad of circumstances where you will get an attorney, but you're kind of saying, oh, is this my attorney? Is this the group's attorney? Is this the hospital's attorney? And are they looking out for my interests? And we talked about this morning because in my practice over the years, I have had occasion to represent multiple parties in the same lawsuit. Now, everyone has to sign off and say, I approve of that, because they all have the right to have their own, if they're sued, their own attorney. But they may want me as well as I represent their partners or something else. It works well, and I have to believe it's ethically appropriate for me to do that, and then the client has to approve it. But there may be circumstances where you don't have that right. You have coverage because your employer has it, and they're going to provide an attorney for you for a deposition, and that attorney has an ethical obligation to you, but they also have an ethical obligation to the company that hired them to defend the case and so forth. Your job in those circumstances is to determine in your mind, is that person representing me, covering me, protecting me, educating me, or not? And if not, all I can tell you is speak up. Speak up. I've never had an instance where someone asked for a separate attorney where either the corporation or the insurance company didn't agree to it. Because once you ask for it, once you suggest that I may not be getting the full representation I desire or need or deserve, they get it for you. It doesn't mean you should every time, but I would just encourage you to have that conversation, and if you have any concerns or doubts, that attorney sitting next to you, you should be confident is there for you. We got a couple minutes?
Sure.
These are some of my favorites. They all fall under the category of just answer the question. So I'm giving away the mistake, but I want to see if you can spot it anyway. All right. Whose decision was it to use sevoflurane?
Me.
Did you discuss that decision with Dr. Bombay?
Sir, this is an acute situation. To me, that is an emergency airway. I'm not going to take the chance of losing her airway, so I did what I needed to do to break the spasm and secure her airway, so I used sevoflurane to help bronchodilate her and break the spasm.
Did anybody catch the mistake there? At 125, you gave her 100 milligrams of propofol.
Yes, sir.
This was still considered a MAC.
No, what happened in between here, which is not shown on this, is by the time we actually had her in lithotomy position, getting her prepped up for the procedure, she started coughing really bad, started coughing very heavily, and her SAT's dropping down to 50.
Is that documented anywhere?
It's not caught up by the computer charting here. So what happened is I automatically grabbed the face mask, turned the APL valve on, gave her some positive pressure, and looked to me, she was spasming from the coughing. So I gave her some propofol and some anesthetic gases to break that spasm, and that's what I did. So propofol is to help break the spasm. The general anesthetic also helps do that too.
So as of 125, you converted to a general?
I did.
That was the question and answer. It should have been. Okay. Did you ever give any sucks to Samantha?
I did when I re-intubated her.
What time?
Not exactly what time it was. That was the exact time, I'm not sure. But I can tell you the sequence of events that occurred if you like.
Sure. Okay. That's the question. Sure.
This will take us to the end of the session.
Yes.
Yeah. You can see it's really long.
All right. Sadly, in that case, the CRNA was desperate to defend not only a bad outcome, but also the absence of documentation. And this is how when the deposition was taken, that was the fact of the case, that there was a lot of things that took place. There was not time during the course of it to do the documentation, and for whatever reason, the CRNA did not think it was appropriate, after everything was over and done, to go back and complete the documentation, identifying medications that were given, best estimates of times, and so forth. And so the deposition was a disaster in part because of that decision that was made many, many months or years before. But it was also, in many respects, a consequence of just not being well prepared and how to deal with some of these questions, and a desperation to defend himself. And so a question like, okay, gave him an opportunity, he thought, to go on for about 10 minutes just describing things that really weren't documented and probably were more in his head than they were in reality. Anyway.
We were just discussing, if you're going back after the effect, you know, if you've taken notes, like or maybe you don't want to take notes, so that your times are closer to what you have done because you can't get to the EMR.
Right.
Do you indicate late entry, or do you just put it in and you back time as we might be?
So it's a great question. The first point that I wish to make, it's not really this case, this seminar, but this is important for all of you. Documentation, putting it into the system, writing it down, recording it, is always more important than not. I've never had a case, almost never had a case, where I wished I had less documentation. Okay? So documenting, filling it out, completing the record is always better than not. Part two, when do you make a note and say that it's a late entry versus I just got around to it because I was intubating, and I wrote intubation and I timed when I did the intubation, but I did it 10 minutes ago. I don't consider that myself to be a late entry, but electronic medical records these days record exactly when the data was input, not just what you did and when you did it, but it also records, you don't necessarily see it, but on audit trails, we can see when the data was actually put in there. So be mindful of electronic medical records. As long as that system is open and you're putting medical information into the system, it's recording what you want to record, but it's also recording when you do it. So do you call it a late entry, or do you just let the computer say, this is when you did it? The short answer is, make sure you do it. And if it's the next shift, the next day, yeah, then you also have to put in late entry.
I just wanted to share an experience that I had early in my career. I worked at a hospital where I was a hospital employee, therefore covered by their liability insurance. The hospital encouraged the CRNAs to become members of a physician CRNA group, which we did. I worked there about 4 or 5 years, went on to another practice. Unbeknownst to me, the physician who was in charge of this group was notified about paying a tail for the liability insurance, However, I never was. 7 years later, I get called to be deposed as a, what do you call it, person in, discovery?
Respondent in discovery.
Respondent in discovery. This was a 21-year-old girl who came in abrupting, and we did an emergency C-section. She did fine with her anesthesia. I stayed with the recovery room nurse because it was like 10:30 at night, and the C-section suite was way far from the desk and any other personnel, so I stayed. Between 25 and 40 minutes after surgery, where she had been awake, talking, and moving all fours, her level of consciousness started to decrease. I called the OB back. I said, something's going on here. I don't know what it is, but this is not good. Anyway, they wanted me as a respondent in discovery. Happily, I find out that I really have no lawyer, attorney, fees, liability coverage, period. Because I was never notified after having been in this group that I had paid no tail. I had no idea I was supposed to. And that guy, the chairman, ran off and took a bunch of money, and the group was disbanded, and So I'm really out there now, and the hospital reached out to me, and I went through the chart with risk management. In fact, I did that when I was still there after this happened, because she went on to die about 7 hours later of a cerebral bleed. But anyway, and I ended up about an hour after we finished the case putting in an art light and intubating her. But anyway, so this was pretty significant. 21-year-old girl comes in and have a baby and dies. And I made significant notes for myself that I kept, plus copies of the lab work that was done. And because I figured, hint, hint, this could be a deal. And so anyway, I find out I'm out there on my own. Happily, the hospital picked up my defense and gave me the hospital attorney. However, that was not the end of the story, because liability insurance companies changed, and every time I had to sign up or renew an insurance policy, I had to go through a 40-page scenario of this whole situation, because they didn't know if they were going to cover me or not. So I also, over the 4 years following this deposition, even though I was released, I didn't do anything wrong, it had serious consequences, because I probably lost about 10 days of work as a result of it, because of when you're changing insurance companies or renewing a contract, they weren't sure if they were going to cover me until I submitted all this. Hallelujah. So, you need to know where your liability insurance is, who's got it, what kind it is, protect yourself. Save yourself a lot of headaches.
Thanks.
Actually, if I could just address a couple of questions that had come up. To Charlie's point, 90% of all claims are settled before they go to court. That means 90% of the time an insurance company is going to decide how a claim is going to be settled. So unless you have your own attorney and insurance that's going to represent your interest probably won't be represented. And if you have your own insurance, even if your attorney, or even if the hospital provides an attorney, if a claim ends up being paid out, you are going to be reported to the National Practitioner Data Bank. And once you're reported to the National Practitioner Data Bank, you are also going to be reported to your State Board of Nursing. You're going to have to go and defend yourself at the State Board of Nursing. Your hospital is not going to pay for that. Your hospital is not going to pay for the expenses that you're going to have by being out of work. So you really should understand or consider what having a supplemental policy can do for you as it relates to that.
We'll just take one last question here, and then we will have, Charlie will remain and answer questions, but go ahead, sir.
You talked earlier about how, Jason from Oklahoma, you talked earlier about the, you control the deposition.
Yes, sir.
You have a deposee and a deposer. You walk into that room and you're not comfortable with, I've never done it. I hope I never have to. There's 85 people in there. I know that's not reality, but you're not comfortable with this guy. I don't know, that's my ex-girlfriend over there. I smashed my TV. can you control the people in the room?
No. I mean, if the people in the room have a legal right to be there. They wouldn't be there otherwise. So they're either a party, can be at any deposition, and a representative of the attorney. So the people that are there, like it or not, are allowed to be there, and you can't get rid of them.
All right, thanks.
So thank you to AANA Insurance Services and MedPro for putting this on. We hope it was informational. And Charlie will be here for some questions afterwards. Sorry, I have to go because I have to line up for a practice